So I've been talking to you guys for the last several months now about a trio of cases that are currently pending before the Arizona Supreme Court. We got the first of those published today in the. These were actually two cases. One out of Yavapai County that was where the court. There's two courts of appeals in the state of Arizona. There's Division 1, which is based in Phoenix and is for everything basically Phoenix and north jurisdiction, and Division 2, which is based in Tucson, that handles pretty much that's all the appeal cases south of Phoenix. And then the Supreme Court is what presides over those two courts. Well, we had a decision from the Yavapai court that said, look, patients don't have any right to Medicaid if they're on probation. If the judge wants to, or if the prosecutors want to, they're free to limit their ability to use marijuana, just like they are to use alcohol or be around children or any other conditions of probation. That was Division 1 out of Phoenix. Division 2 out of Tucson said, no. This creates, patients have a legal right to Medicaid. It's a privilege that is specifically cannot be taken away from them for as long as they're in compliance with the Medical Marijuana Act. That they're not possessing 2.5 ounces and otherwise, in compliance with the act. You can't take it away from them, and you also cannot penalize, specifically can't subject patients to a penalty if they are acting in compliance with the Medical Marijuana Act. It doesn't say anywhere there except when they're on probation, and we're not going to read into anything that the voters haven't specifically passed. So these two came head to head before the Supreme Court. The Supreme Court had to decide which Court of Appeals was right, and they sided with Division 2, and simply, in a beautiful opinion, did away with pretty much every argument that the state has been making over the course of the last 4 years against the Medical Marijuana Act, and said patients have the right, nobody can take it away from them. That's in Reed Keller out of Tucson. And this has a couple things. Not only does it allow people who are on probation to continue to medicate despite what the judge or prosecutor thinks about it, it also says that you can't waive that right. That no matter, they can't say, well, look, put it into a plea agreement. It's not waivable. It's inalienable. You can't even agree to waive it yourself. It's your right under the Medical Marijuana Act. Now, not only does it have that immediate effect, but also it signals, I think, this is the first case that the Supreme Court has ever actually upheld the Medical Marijuana Act. We had a little bit of what they call dicta in an opinion last year. It was a DUI case, and they said something about, look, we shouldn't let anybody be prosecuted for inactive metabolites. After all, what about patients? They're legally allowed to use, and that wouldn't be fair to them. And it was like, oh wow, that was a little bit of an indication that they actually thought that the Medical Marijuana Act was valid. But never yet have we. This is the first case where they said this initiative is legal. It is going to be enforced. And here's a message to all the law enforcement, prosecutors, and judges out there. We're not going to tolerate, the Supreme Court will not tolerate any attempt to water down or frustrate the will of the people or the intent, the purpose of the initiative. So that's huge. So we know it's here to stay. And that includes, by the way, one of the specific arguments that was made in these cases, and I have a copy if anyone wants to look at it, was that federal law conflicted with the Arizona Medical Marijuana Act and preempted the Medical Marijuana Act. They've been making this argument from the beginning. We had the first case the governor filed in the federal district court. I represented the dispensary industry at the time was in a group called the Arizona Association of Dispensary Professionals, and we filed a motion to dismiss. I co-authored that with the attorney from the ACLU. The judge agreed to dismiss the case. Bill Montgomery, our county attorney, not to be discouraged, then demanded that the County Board of Commissioners enact zoning regulations that precluded any dispensary from opening in Maricopa County, unincorporated Maricopa County. That's what the White Mountain case is. Somebody who wanted to have a dispensary in unincorporated Maricopa County said, you can't do that. That you have to allow us to open a dispensary, you can only pass reasonable zoning restrictions pertaining to the location. You can't outlaw it. That case morphed then into this battle of whether the Arizona Medical Marijuana Act was going to be upheld or not, and the chief argument was it conflicted with federal law, the whole thing is illegal, and the court must declare it unconstitutional and end this thing once and for all.
State court,
The
right?
Supreme Court, the Court of Appeals, the Court of Appeals had this case. In fact, Bill Montgomery attempted to leapfrog the Court of Appeals and go directly to the Supreme Court, and the Supreme Court was like, you don't get to, you have to go through the process like everybody else and send them back to the Court of Appeals. If, you can ask us to look at your case after you get done at the Court of Appeals. The court went back to the Court of Appeals, but by then we filed these cases, like this one, in front of the Supreme Court, and the Court of Appeals said to Bill Montgomery, you're going to have to wait. We're not going to decide this issue. The Supreme Court has this issue now because they're the Yavapai County Attorney's Office, the Cochise County Attorney's Office, other county attorneys' offices in these cases was making the preemption argument that it conflicts with. And he said, we're going to hold off on making a decision in your case, Bill, on your White Mountain case until after we hear from the Supreme Court. Well, we've heard from them. They specifically addressed the preemption argument. They said it's stupid and that this law is not preempted by federal law. It is enforceable. That's the final say on it, which means that the White Mountain case will probably be dismissed within the next few weeks. It's a dead issue.
I'm going to send that to Bill tonight.
We'll do questions in just a second if you could just remember your question. Two other cases now pending in the Supreme Court that I think this signals a favorable decision on is whether patients have immunity for DUI and then there's a statute that precludes patients from possessing on university campuses and college campuses. Those are the two other medical marijuana cases in the Supreme Court. I think that this, if anything, now has indicated that we're probably going to get favorable opinions in those cases as well. We'll be getting those decisions in the coming months. Of course, this also impacts cases that are currently pending with the Supreme Court. For example, out of Pima County, we have the Matlock case, which is whether patients are prohibited from selling, receiving compensation, but for transferring marijuana to other patients. This Supreme Court case will obviously influence the Court of Appeals judges because they don't want to get overruled right by the Supreme Court, and now it's definitive. The Supreme Court has come down very heavily in support of the Medical Marijuana Act. I think that could influence some of these other decisions that are on their way up, and of course on trial levels as well. Like Kyle Caitlin's case, it's down in Pima County right now. That case, I think, in some of the judges' decisions throughout the trial, which began today, I think, right? Will probably be informed by this case. The judge didn't have a chance to see it yet. I'm sure it's on his desk today, but I'm sure that will influence some of his decisions about how he decides what to allow and what not to allow during Kyle Caitlin's case. So that's what's going on in the legal things. The initiatives on the medical thing rather, the initiatives on the legalization side, which everyone is very interested in hearing about, and is very fluid right now, with two competing groups, the MPP and a new group that's kind of split off from the MPP, the ARL, I don't want to say ALR for some, ARL group, who has announced that they're working on a competing initiative. I think that National Normal's position is not to intervene in state, political processes. I understand that. I don't think in any way, however, that is meant to discourage normal members from, weighing in clearly on what they feel is important to be included in any initiative that reaches the ballot. And without exception, that has always been whatever is most favorable to patients, to consumers, to marijuana consumers. It's always been that and nothing else. There's no consumer interest. There's no big corporate interest. There's no little corporate interest or little commercial interest. None of that matters to Normal. All they care about is what's going to benefit the consumer the most. And then whatever initiative does that the most, that's the one that they get behind. But in the meantime, look, Normal is part of the effort to articulate to the groups who have these initiatives on the table, MPP and ARL, what we feel those necessary provisions are. And this has been articulated not just by Normal, but every other member of the Arizona Cannabis Consumer Coalition, which is made up of multiple groups, including Safer Arizona, Normal, Phoenix Cannabis Coalition, Students for a Sensible Drug Policy, the Alpine Cannabis Coalition, RAMP, Camp 420, Cannabis, and other groups that are in this coalition that have whose leadership communicates their members' feelings on this, and it's boiled down to a very, in my opinion, and again, it's not like I'm the president of the Cannabis Consumer Coalition, but my sense from having been involved in the process of working with all these different organizations in the coalition is here's what's fundamental to us. And who are we going to get behind? Whoever most closely is able to accomplish the following. One, the defelonization of all marijuana crimes, save maybe for the most large scale, like multiple pounds, perhaps can remain under the current criminal code as high-level felonies subjecting people to mandatory prison time. Because right now, for example, MPP's talked about including a provision that allows for personal cultivation of 6 plants. We support that. That's another one of our planks in the Consumer Foundation is we want personal cultivation. That has to be included in any initiative that we're going to be enthusiastically involved in. Okay. However, 6. But check this out. 6 mature plants is going to weigh more than 2 pounds, right?
It will.
So guess what?
You hope so.
If anyone, if something goes radically wrong, that's going to. So here's the problem. If a person grows 7 plants, they have to go. That's mandatory prison. That's anything more involving any production case under the criminal code involving more than 2 pounds is mandatory prison, like 5 years. Okay. So anybody who ends up, oh, shit, there's a clone sticking in here and it grew a root. Now I have 7 plants. You're going to go to prison unless you take some felony deal that destroys your, life and imposes all these other harsh penalties. If you try, that's a mandatory prison offense. Any marijuana crime over 2 pounds. So, in my opinion, how can you provide for? How can you have an initiative that doesn't provide for the defelonization of at least a middle tier? Okay, you're under the current initiative that the MVP has proposed. For example, you're allowed to possess 1 ounce of marijuana. Great, that's great. But what about people that possess between 1 ounce and say a couple pounds? That means they gotta be convicted and go to prison, maybe. In some cases, you have to go to prison if they get convicted at trial. Well, wait a minute. What about a middle tier that provides a buffer between purely decriminalized conduct, and then and between that and clearly black market, like cartel level type stuff? Shouldn't there be a buffer that protects us from going to prison for that middle tier of violations? So every marijuana crime, whether it's sales, importation, transportation, production, that is above the decriminalized amount. And by the way, there's no decriminalized amount for sales, but still, we ought to have this protection, this buffer for when that happens to people. Because even if you're not selling, if you possess more than a certain amount, the county attorney's office is going to charge you with possession for sale, just on the amount alone, and mandatory prison. Shouldn't we have a buffer in there that says it's okay? Worst that's going to happen is you're going to get a misdemeanor, pay a fine, but you don't have to worry about going to prison. You don't have to worry about losing all your civil rights. You don't have to worry about having your life destroyed. There's a penalty, but it's not the end of your life. Okay, so that's something that I think we consumers have to take very seriously. Defelonization, okay, of those offenses that are above what's been decriminalized. Number 2 is the personal cultivation that I talked about. Number 3 is we got to have. If there's one thing that we know right now that Americans overwhelmingly support, in not just marijuana, but especially marijuana, but all drugs, but especially marijuana, is we got to get nonviolent offenders out of prison.
Yeah.
The time is over. We have more people in prison than any other nation on earth, including in communist China, and more of a percentage of our population in prison than any other nation on earth, including the worst dictatorships, North Korea, Iran, you name it. We got more. Why? Because we have a war on drugs that's destroying families and individual lives, and incentivizing law enforcement to ignore violent crimes and ignore economic crimes, and in favor of going after nonviolent drug-related offenses, many of whom, and this isn't so much true in marijuana, but many of whom in the broader war on drugs are people who are addicts, like we were talking about methamphetamine, cocaine, heroin, have a history of child abuse and so forth, and we're putting them in prison. I listened to an interview today about a woman who went to prison here in Arizona a few years ago on a methamphetamine sales charge, and here in Arizona prison, and was to be disciplined, was put in a cage without a roof, out in the sun in Arizona, cried and cried, defecated all over the place, begged for water, wasn't given any till she cooked to death in an Arizona prison in a cage out in the sun. That's what the kind of thing is. The American people are fed up with that, and they want nonviolent drug offenders, especially marijuana offenders, to be out of prison. So it's Talk to me about optics, okay? We hear that word a lot, right? Optics. What looks right to the voters? Well, I'll tell you one thing that looks right to the voters is get nonviolent offenders out of prison. If there's anything that all the voters agree to, it's that. Why isn't that in the initiative? Yeah. Why is that not in the initiative? Those are things that have yet to be addressed. The MPP, for example, and I know that I'm talking about the MPP because I know that we're going to give time to the ARL to talk about their initiative, so and we'll hear what has to be said about that. But the MPP, I think, now has agreed, we'll see, that personal cultivation will make its way back into the initiative. Great. Let's applaud MPP. They agreed to one of our demands, which was that they have to put a clear provision in there that prevents people from being prosecuted and convicted for the automatic DUI, for just having marijuana in their system. They've included that in their initiative. That's Third, we insisted that parental rights were protected and that people won't lose their children because they happen to choose to use marijuana lawfully under the legalization initiative. The Marijuana Policy Project has also agreed to include that provision. What's left, though, are two of the most critical provisions, which we just talked about, is the defelonization of marijuana crimes, a middle tier of marijuana crimes, and post-conviction relief. So if Kyle Caitlin ends up getting convicted and sent to prison, then we get this passed in 2016, he can get out. And we all have friends who are looking at mandatory prison right now, and it's those people that we have to think about when we say we need to have this post-conviction relief, where a person can petition the court with a motion to modify the sentence and get them out of prison or off probation. Okay, if they would have been sentenced differently under the new initiative. Okay, the new law. All right, now a lot of that is Tom Dean, and what I believe is important. I think it reflects what most of you also agreed to, because we've been listening very closely to you. This is what this coalition is all about, that all of our groups are a part of. And so I'm not speaking on behalf of National Normal or on behalf of Normal, Darren's state, but I am saying that everything I just said, nobody at Normal would disagree with a single thing and would also be up applauding. Keith Straub would be applauding everything I just said without question, okay? So if you're a member of Normal, then Darren doesn't mean to suggest that you should just sit back and let things pan out and then decide which initiative you want to be behind. He's not suggesting that at all. I don't think he's suggesting that at all. So members of Normal, you have to stand up and be united with Safer Arizona, Cannabis, the Phoenix Cannabis Coalition, the Students for Sensible Drug Policy, Yavapai Cannabis Coalition, RAMP. Where's Billy? Billy's here. RAMP, the Human Solution. I can never see Billy.
SSDP.
One of the tallest guys in the room.
All of us, I believe, Dennis is here, all of us agree that these provisions are critical and indispensable to any initiative that we can really get behind. And those initiatives that don't include provisions like this, that we're very motivated to actually stand against. Okay, and And you know what? Even if possibly that means our own competing initiative, if that's what it takes. This is serious, man. We're not playing around. We want this initiative. We're not asking for anything that the people don't want. And if
That's
it's against
right.
what the dispensaries want, I don't know what to tell you, man. Sorry. You know?
Yeah,
Sorry.
exactly.
We'll wait for it. If we have to, we'll wait. If we want the right law passed, okay? That's Tom Dean, all right? And if you guys agree with me, great. I'm not speaking on behalf of anybody else but myself, but I believe that this is what you all feel too, and in your hearts, and that's what we do. We act on what we know is right in our heart. That's all that I ask anyone to do.
To actually do speak for somebody else, in case people don't know, Tom is our in-house lawyer at Safe Arizona, and the statements he makes, we back 100%.
Okay, well, thank you very much.
We stand with what you just said 100%.
All right, great. Absolutely, okay. Oh, and the latest